The floor is yours. Which case do you want to get into first?
Thanks, John. Well, first, because it's applicable to everybody, I was going to just talk a little bit about matter of PAC, and I know that you were talking about it a bit on the social media and on your and on the podcast and on your page. It's published by the board earlier in November, and it's the one about I-130 and 204C bar, in which the board is essentially saying that even if there hasn't been a 204C finding in a previous I-130 petition, the non-citizen can be 204C barred in their subsequent I-130 based on a new marriage. And that is, the quote is, all that's required to make a Section 204C marriage fraud finding is, quote, evidence of the attempt or conspiracy must be contained in the alien's file, end quote. So that's pretty broad. Yeah. And, it seems to me, based on what the board is doing with matter of PAC and matter of Ortega, which came out earlier this year, is they're really tightening the bar on I-130s and marriage-based immigration. And so with matter of Ortega, that was a K visa, consular processing, which the individual tried to come in on a K visa many years prior, and actually there was not even an I-130 petition filed. But there was an evidence of an attempt, and he didn't even come in on it. And I believe that he withdrew the application first, but there was just some evidence of it. And the board found in Ortega that alone would qualify, unless Mr. Ortega could overcome it, to bar him from his subsequent I-130 petition. Now with matter of PAC, they're saying very clearly that you don't even need to make that prior finding before. They can make it at the time of the I-130 interview. So really, when you do an I-130, if there's a prior marriage, even if they haven't applied for an I-130, I'm advising clients that we're essentially doing two I-130 interviews. Both marriages are on the table as if you were prepping both of them to the legitimacy of those marriages. I don't know what you think about that.
This year I had several people contact me where not only they have adjustment interviews that had this issue before this decision, but also at the I-751 removal and at naturalization, where they even rescinded the green card based on a previous marriage case. And it was very shocking when I received it, this kind of news, because it leaves these people at a really bad position. They might have had a marriage 10, 15 years ago, and there's no evidence. They don't even know where that previous spouse was to even get them involved. So it's very nasty. So I tell them, listen, like you said, this is two cases. And I had a consult with somebody a couple months ago on this, and I said, we have to prove both. And they balked. They're like, oh, that's crazy. That's not the case. Other lawyers didn't say this. I'm like, no, I've seen, it was before the decision came, but the new one, but I saw the writing on the wall from the previous consult or calls I had. And so you got to prep both of them. And you got to get into marriage history of people when they come in for the I-130 and see if they filed something. This is primarily I've seen when people have already filed something and either they withdrew it or the case was denied at the interview. They couldn't make a fraud finding, but they just said there's not enough bona fides. But just be prepared for the worst. This is, even if the president changes, they still have their people in, and the bureaucracy doesn't change that quickly to return back once these decisions are made. So right, I agree. Yeah, you got to prep both cases.
As well as I do that in a USCIS interview, the attorney doesn't have as much power as we would like. It's not like being in court. And so there's very little we can do to prevent a line of questioning about that prior marriage in the interview. So you got to prep. And clients who tell you otherwise are probably going to be bad clients anyway.
Yeah. And, sometimes they don't want to talk about the previous relationship or it's uncomfortable. But it's just like, it's better safe than sorry because this is the situation coming. Again, I saw a guy get rescinded ad nat. So they got the nats denied and they got a rescission order, which is really kind of crazy because usually I don't see rescission, even though that's usually just. And the thing about rescission is once they make that decision, it's kind of an internal thing. Then you have to get called for removals. I was studying it. It's such a more complicated thing. Whereas if the 5 years had passed and then they just NTA'd him, that's different than just rescinding it, where then you have to procedurally follow up. So it was it's a really messy situation. So if you have a NATS case even, so again, not even the I-130, but guy comes in 3-year NATS because I'm married U.S. citizen, you got to get in that relationship history and track it back because it's all this stuff is going to follow you forever.
Maybe I'm just paranoid, but if rescission scares me very much. If a naturalization, somebody maybe wants to naturalize based on their marriage to a U.S. citizen, they can do it in 3 years. If they come in, if there is anything, I say, dude, just wait 5 years. I don't even want to risk them rescinding it. I'd rather fight it out in court. Rescission is a scary little thing.
because people want that nat. So talking them out of the 3-year version of it
Yeah.
is like hard, but yeah, you don't want to deal with rescission, so much extra procedural stuff and place just the rescission statute kind of works against you, deeply works against you. Um, and it's a lot of times misunderstood. People think if they don't catch you after 5 years, you're good, which is not the case. It's just a weird situation. But thank you for that. I'm glad we talked as much as possible about this because I think this is a major issue that hits a lot of people really hard. And so all practitioners always have to keep this one in mind. And this could follow you because there are so many cases where people do get married, they get divorced, and it just works out this way.
Yeah. Right. So
Yeah.
that's clearly what the board is trying to do. Matter of Pac, matter of Ortega. We'll see if there'll be something else on that. We'll see what a Biden administration's board does too. It's all so up in the air. Nobody who I know, and I know a lot of people who know people who may be in the administration. Nobody actually seems to know what's going to happen. We just kind of have our hopes.
The problem with this is the fraud finding. Fraud is what clear and convincing evidence. That's is a higher standard, isn't it?
It's substantial. The evidence is, and I want to get the quote right. There must be substantial and probative evidence of an attempt or conspiracy to enter into the marriage for purposes of evading immigration law. Substantial and probative is higher than a preponderance.
Yeah, that's not clear and convincing.
Yeah,
it just due process wise, it's so unfair after the fact, after so much time has passed, where it's hard to defend yourself to throw that out. If the original I-130 was denied, let's say for lack of bona fides, that's the time that they should have to call it out for something like this. I mean, they probably always had the power to come back later and accuse you of this, but it just puts people at such a disadvantage unless there's really clear evidence of fraud. Because sometimes you get divorced and that ex-wife or ex-husband's angry, and then they go and call USCIS, say this guy lied to me, this gal lied to me, or they cheated, or just bad faith kind of stuff. Which it might have been a okay marriage, just the foreign spouse did something wrong, or all these family issues that pop up. So it really puts the alien at a disadvantage. Just further really makes it hard to be a foreigner in the United States. Even the easy case, the marriage adjustment case or marriage counsel processing case, which is considered easy, there's no easiness involved.
Right.